Fast forward, Yenikomo El Shana Yisu Ha, AG Politics Avenue. Unia, Podcast was training, a make ways make headlines. And Unia Yajam Rena Idibi, Exum, Bonidim Yahuraxim. Mesra say, Yanko a year in Simu, na a year Getrude Torkonoo, Okupimu, ECOWAS court. Proceedings a court so Unia, a ma ECOWAS court, etimi a warning contest and some hour the Abadan. Any Yanasubia and sign a for when you go a year Ghana, my mom. Unia, Sansem Nina about Tenswa, Manocase, Alfredo Kansi, Ajemre, na Obo in Chirimu, Efa and Semahodua, a year judges, a hodua mutra, Semenso, and so a kind. I am not subscribed to the channel.
It is from the Deputy Attorney General regarding. Thank you.
Yes.
Regarding the ruling of the ECOWAS court. This is it. Quickly. And Justice Shemsai put this out earlier in the week that the ECOWAS Community Court has dismissed all of the 7 claims which the former Chief Justice, her Ladyship Justice Getrude Torkonoo, brought against the Republic in respect of her Ladyship's claim of $10 million damages. The court held that, quote, in light of the court's conclusions that Ghana has not violated any of the applicant's rights under the Africa Charter as alleged, the court makes no decision on reparations. And this is the proceedings as we monitored. 1. And specific to Justice Torkonoo's case per the Africa Charter on Human Rights. The reason why there was a demand for the $10 million damage. 1, that suspension and removal from office were arbitrary and in violation of her right to a fair hearing and due process. A specific reference was made to Article 7 of the Africa Charter. B, the inquiry committee was illegally constituted and affected by bias. That's the second claim. The third, that she was denied access to a judicially reasoned opinion of the prima facie determination and the inquiry committee report in violation of her right to information. That is Article 9. D, the process violated her right to dignity and protection from arbitrary treatment. E, the removal violated her right to work. F, the conduct of the respondent breached the principle of less penance. G, compensation for $10 million for moral and reputational damage. And this was the determination of the ECOWAS court. Government of Ghana via committee fulfilled its obligations of fair hearing, number 1. Government of Ghana did not violate applicants' rights to be heard under Article 7 of the Africa Charter. Prima facie determination did not violate fair hearing principle. It is a filtering mechanism. So, this grounds without merit only courts in Ghana that have jurisdiction over procedural matters of quasi-judicial bodies, and the ECOWAS court on the matter of the competence and impartiality of Article 146 committee, they declined to review the merit of the committee's findings. They said they don't have jurisdiction over that particular matter. Suspension from office by president did not violate the applicant's right to work. That's the ECOWAS court's verdict. The applicant was not unfairly and arbitrarily removed from office as Chief Justice of Ghana. Decision to focus on single petition for her removal was not irregular. And they also say court rejected arguments that bodily search, failure to have family present during hearing, and choice of venue were a violation of her right to dignity. And then also the court held that bodily search was reasonable and proportionate. And finally, the applicant did not make an official request for committee report. Hence, the court does not find her rights violated. Start off with you, Mr. Anu, on this, quickly.
Well, I'll be honest with you. This is one of the national level incidents that I always had some kind of disquiet about. Throughout, I kept quiet because I wasn't clear in my mind whether I was sufficiently apprised of facts to draw a conclusion. And I think I was also worried about the trajectory. We had started earlier with removal of electoral commissioners. We had escalated to chief justices, and I was wondering what next. I think that this, for me, was a very unfortunate milestone in the history of our nation. I think that there are lessons to be learnt that must be learnt well. My brother Samson Ladianyini gave me some, legal understanding of the background that made me think differently about the scenario. I think it's good that she's exploring all the opportunities of venues. It's good to see the feedback. It probably gives us more confidence in what happened internally. I think that at the end of the day, what bothers me is I was wondering whether if she ended up with nothing at all, were we really fair to her? So those would be my comments. I think that I'll leave it to the lawyers who probably are better versed in these matters. But personally, it's one of those times in the history of this nation that I felt a lot of disquiet. I was not quite sure whether this is the kind of thing that should have happened. I don't know whether in selecting people for these offices and in protecting and ensuring that the institutional systems work to ensure that things work out. There are things that we could do as a result of this experience to ensure that we don't go through this cycle again. And I don't want to see another situation where we have chief justices having to be removed or any other such high officials. Whatever needs to be done to strengthen their alignment with administrative processes, with what is required, I think it is necessary we look at that.
Well, you talked about she exploring all the other avenues. There are about 4 other cases in respect of her removal, which is still active at the Supreme Court. The Supreme Court has decided to consolidate all 4. July 2, which is just some few days. Next week, Thursday.
Okay.
There's going to be a
blockbuster.
So this is the panel that would sit on that consolidated case of 7.
So see, I agree with my brother here. It's worrying, and for some people, it's even now exhausting. Okay, but he concluded by saying he doesn't want to see another Chief Justice hounded this way. We have set ourselves
hounded.
No, I didn't say hounded. No. He didn't use the word.
You are using hounded.
He didn't use the word. He said he didn't want to see another Chief Justice more or less treated this way. Okay, but the point I'm making, and I use the word hounded.
Oh,
I use the word hounded. Please. Okay, and I go to what Justice Sophia Akuffo said. And I respect her so much for standing up.
What did she say?
That this is not something upon which you take out a Chief Justice.
Oh.
Okay?
Let's institutionalize it. At the end of every government's tenure, let's have a situation where we open up and say, any citizen who has information that is worth considering, because the internal audit may not have captured everything. There may be some additional information. Let's harvest that as well. I think that is important. I think there's the issue of the non-fit for purpose asset declaration. Unless we change that regime and make it something that is public. So somebody in Kukuruntumi who realizes that you've not declared your land and I know that you have land there, can raise that attention. Our Nigerian brothers have done it. Why can't we do that? There's the issue of the COPO, Conduct of Public Officers Bill, which we need that law in place. That, for me, is the standard. Because it is not in place, there's a lot of difficulty understanding how do you actually prosecute and sanction a public officer. We seem to be going around in circles. It's good the president has something, but that doesn't have legal value.
Senator, with respect, I think just recently he announced that the state asset protection law is also coming. Yeah. Because you see, you need to also single out state property and state asset. Article 40, that's Article 40 of the Constitution enjoins all of us as citizens, 41, enjoins all of us as citizens to ensure the protection and prevent the misuse of public. But I think this one is a targeted legislation that President Mahama wants to come with penal consequences with it, targeted at protection of public property or assets Because you see, at the bottom, all of us don't.
We have some scratchy laws. Let's just say there is already law on protection of public health. 1979, there is an AFRCD.
It's problematic.
But what
even the consequences compared to today is
so we need the asset declaration law first.
No, I mean the two can run
together. So I'm just pointing out we have, for example, and look, unexplained wealth. We need a proper unexplained wealth law with reverse burden of proof to make it easier for these cases to be run. We need specialized anti-corruption courts. I have seen in other jurisdictions where within 6 months, they are sitting daily, they clear it. So the penal understanding of what will happen to you if you dare decide that you're going to get corrupt, you see it within 6 months. Everybody can see the case has ended. So there are things we need to do, including better resourcing of anti-corruption agencies in general. In addition to talking about the 1 year, because if we do these things, then within the tenure of that government, you will find that anti-corruption agencies can work faster. Otherwise, you can put the 1 year, and beyond the 1 year, there will be cases that we've not yet gotten to the point where we can charge the people, and therefore what do? They move out of jurisdiction, and then we have a problem. So yes, I think Kofi has value when he says, let's add this to the basket of things we have, but I think we need to strengthen what exists. We need to go beyond that. We need unexplained wealth law with reverse burden of proof, and think through what we need to pull together. Let's say a comprehensive law that pulls these pieces together in a way that allows us to get better results than we have seen so far. And that will be my take on it.
So, yes, there should be consideration.
You know, it has been suggested that if we list state companies and people have invested in it,
by itself, it will not be a panacea.
You were even here before.
It's not going to be a panacea by itself. In itself.
By itself, it will not be a panacea. You need all these other things completely dealt with in a more comprehensive way. Otherwise, we'll still be struggling, and then we'll come back and say we don't seem to be doing much in the fight against corruption.
To ensure it doesn't just come up to add to all the many legislations we have already in place to fight corruption, and I'll give you the. I'm rounding up on this.
I think he will, in a way, wrap up because that's his proposal.
Yes,
so I'm just
only
reiterating the point of conscience that ADG.
But you said that
if we're talking of conscience, that we must not be selective in terms of our delivery. What did we do? What have we painted so far to the people of this country? We come in, people we think must go through the rigors of the law. We use the authority of the Attorney General to just invoke nolle prosequa
made that point
on people who served in very critical positions, like Atoforsen, Richard Dakwa, like Stephen Oponi,
there was no nolle prosequa. I am surprised that today you have the courage to even talk about Atoforsen.
No, I'm coming. Let me make my point.
The distasteful conduct of your Attorney General. You should talk about
you come and use nolle prosequa to exonerate them.
You are not sure.
Two, you Sedina. When was she?
That's the conscience.
When was she brought into the country? And where was she? Why was she just sent to Nsawam just this
let Ken come.
And you were talking of
let Ken have that courage to come.
And do house arrest.
I mean, so
I'll be among his lawyers to apply for bail for him. Let him come. You let Ken come.
With this posture,
you can't.
With this posture, and the international community,
you are afraid you expose your government.
The optics, in a way, indicate that you want to persecute him.
How?
With this posture.
With this posture. When I'm offering to apply for bail for him, I'm offering to apply for bail for him.
Filing what bail?
If he can, there are charges against him. His lawyers will apply for bail.
So if we are talking of conscience, then we need to love our country to in a way exhibit that kind of willingness and commitment towards protecting the purse of this country rather than protecting our individual interests as far as our party is concerned.
You see,
that if it is not an NDC,
in a public
if it's not an NDC, then
the courage alone is fascinating. I mean, the courage to talk about public purse is fascinating.
Why?
Okay, one sentence.
The holder of the public purse is running away from justice.
You see how he's heckling? I allowed you to make your point.
When President Kufuor was exiting, I am aware that he caused the discontinuance of the case against what Kunedu and his
don't even dignify him. He's a lawyer. He knows Nole Prosca is permissible by law.
You see?
That's
Because
what
this is the first
so you come into government and you just apply
so it means that
and you talk
was using the state just to persecute Kunedu and
you have the will to
that's what Kufuor was doing.
You have made your point.
That's what Kufuor was doing.
You have made your point.
Selective justice.
Thank you.
Indeed.
Mr. Mento, let's round up on this quickly.
See, look, from my days of ECOWAS president, which you talk about 1991, okay, before Rollins. Okay, look, going down the line, occupied Ghana, what? Just Google my name against Ejapa. This is Ken Oforiatta's Ejapa, what they proposed. Ask who were the leaders against that fight. I'm talking about what we have done or I have done with others on, anti-corruption. Okay?
It's even a good proposal.
Please. Now, when we talk about these broad things, look, you never stop building a nation. You keep going. So as we move, the things we need to do, we add to them. It is unfair and it is defeatist to make it about Ken Oforiatta. But the fact about Ken Oforiatta is that, one, the system has created a situation that has inured to his benefit. And I said that a year before it happened. Okay, when I told you, Martin is my brother, please. When we argued and finished, later he found out, and then you mounted an attack against the OSP.
Yeah, first I didn't know he was deceiving us.
Okay, so look, sometimes you can listen to what I say and not understand it. I have said, and I said it long before, that the way this thing was going was wrong and was going to inure to Ken's benefit. Two, I said that given the atmosphere that was being created, no serious lawyer would advise Ken to come back. Three, I said that if you have a situation where people are demonstrating against him, his name is being mentioned and demonized, when he has not been charged, you will create a situation where the U.S., it will raise a platform for him to seek asylum. It has happened, it has been granted. The U.S. courts have actually said some
not asylum. He got green card.
No, he will claim asylum.
No, once he has
you are not listening to me. I said he will claim it. The U.S. government has not given him asylum, but they have strengthened his position. The point I'm making is this is not about Ken. But if you want to talk about Ken, okay, the mistakes within this system is what has given rise to the situation where we are in. Now, back to the
maybe we'll name the legislation Ken Oforiatta.
Exactly.
Again, you are making a mistake.
It's very important.
Let me finish my point.
As if you're on a political platform.
Please.
Please.
As if you're on a political platform. Why do you do this to Ken?
Excuse me.
Why do you do this to Ken?
Hello.
Let's legally present our views.
But it's legal.
Why not?
You have made your point.
Style of advocacy. A style of persuasion.
Thank you very much.
The government of this is that we need to improve the accountability systems which the politicians find.
We ain't somehow waiting for so channel so. Mam ena was Saudi bread. That's an so bad in the European.